Friends, I welcome you all to CA series, lecture number 1 of Indian Partnership Act 1932. I am your mentor Shekhar Gehlot. These classes are sponsored by Sri Jendra Rank Zone. Okay, so now we will begin with another very important subject in the CA exam series, that is Indian Partnership Act. Okay, now Indian Partnership Act, when we talk about partnership, you must understand the distinction between partnership and the company which is formed under a Companies Act. Okay, we had a Partnership Act before Companies Act. Okay, so now let us understand why these two entities, a partnership or a company, are distinct. Throughout the chapter, we will see a lot of distinction between the company and a partnership. Okay, so you give it a brief reading. This is the first, we'll begin with topic A, that is general nature of partnership. This is a flow chart of what we are going to discuss. Give it a brief reading and then we will start discussing. I'm sorry, there is some issue with the computer. Okay, now let us begin. So, in this topic, we are going to discuss what is partnership, okay, and what are the, I mean, how do we understand partnership? Okay, what is partnership? This question, how do we answer it? We'll understand the essential elements of a partnership. What is a partnership and what is the true test of partnership? Okay, because some relationships may appear like a partnership and may not be a partnership. So, we'll understand the relation between partnership, true essential elements of partnership, and what is the true test to determine whether two people are employer employee or they are partners. Okay, or they may be co-owners but may not be partners. We'll see it later on. Okay, distinction with other forms of organization, how partnership is other than joint stock company or a club or a Hindu undivided family or co-ownership or association. And then we'll proceed with what are the types of partners which are envisaged under the Partnership Act. What are the types of partners we have in a partnership? Partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Okay. So partnership is a Relation. What is partnership? Partnership is not name of something, name of an entity. Partnership is name of a relation which we give. Okay, partnership is name of a relation. Okay, partnership itself is no entity at all. It does not exist at all. It's a legal fiction. What actually partnership is? Partnership is it's a name of relationship. It's a name of relationship. Okay, like we have brother, sister, mother, wife, husband, father, etc. These are the name of relationships. Okay. Similarly, the name of relationship which exists between persons, a relationship which exists between persons who have agreed to share the profits of a business. That means they are going to carry on some business activity and they'll share the profits among themselves. Okay, which is carried by all of them or any one of them acting for all. Okay, this kind of relationship between people is known as partnership. Okay, partnership is itself not a legal entity. Company is a legal entity. Partnership is not a legal entity. By the definition itself, it is clear partnership is just a relation, name of the relationship. Okay, we have relationships and then we name those relationship. Okay, like I just discussed, father, mother, husband, wife. We name those relations. Okay, what is the relation between these two people? They are husband, wife. Okay, similarly, what is the relation between these two people? They are partners. In a partnership, what is the partnership? The relationship. Okay. Persons who have entered into partnership with one another are called individually partners. Individually, they are called partners, okay, and collectively a firm. Collectively, the members of this partnership, individually known as partners, collectively as firm. Collectively, they are known as firm. And the name under which they partner, the business is carried on is called the firm name. Whatever name they may have suggested, ABC, BXY, Messrs, etc. Elements of partnership. Okay, elements of partnership, or you may even call them essentials of a partnership, or you may call them essentials of a partnership. Now, it is very much important to understand something, that we should read the essentials of it. Till the time we do not know the essentials of it, we are not able to understand the relation particularly, okay, typically and in a detailed manner. So, we'll first begin with the essentials of a partnership. The definition of partnership contains the following five elements. It contains following five elements which must coexist before a partnership can come into existence. Coexist means all must exist at the same time. Even if one is missing, okay, even if one is missing, the partnership may not be partnership. Let's substitute this may with shall. Relationship shall not be a partnership. That means all these five and coexistence of these together is mandatory because of the definition given in the act, and we are bound by the act only. Partnership is an association of two or more persons. This is the first point. Okay, it is an association of two or more persons. The partnership must be a result of an agreement entered into by all persons concerned. There must be an agreement, and when we are talking about agreement, there must be all essentials of the agreement being fulfilled. Okay, partnership is organized to carry on some business. They are carrying on some business. Okay, what is a business? We'll see later. The agreement must be to share the profits under partnership. There must be an agreement that we will share the profits. Okay. The business must be carried on by all of them or anyone acting on their behalf. These are the five elements. Where do we get these five elements from? We get these five elements from the partnership definition, which says partnership is the relation between persons who have agreed to share the profits of business carried on by all or any of them acting for all. Okay. Now let us read them one by one. First one is association of two or more persons. Partnership is an association of two or more persons. Again, only persons recognized by law can enter into an agreement of partnership. Therefore, a firm, since it is not a person recognized in the eyes of law, cannot be a partner. Again, a minor cannot be a partner in a firm, but with the consent of all the partners, may be admitted to the benefits of partnership. The Partnership Act is silent about the maximum number of partners, but Section 464 of the Companies Act 2013 has now put a limit of 50 partners in any association or partnership firm. Okay, in any association or partnership firm. Now, let us see. Partnership is association of two or more persons. That means one person alone himself cannot be in partnership with himself. Okay, one person alone cannot establish a partnership. Okay, one person alone cannot establish a partnership. One person alone can set up a one person company now, but he cannot set up a partnership. There are at least two or more than two persons required. And how much maximum they can be? They can be around 50 now, as per the limit set by the Section 464 of the Companies Act 2013. Okay, now again, only persons recognized by law can enter into an agreement. Persons recognized by law. What are persons recognized by law? Let us say individual, that is a living being, then artificial. Individual and artificial. Artificials are like company. Can a company be a partner in a partnership firm? Yes, it can be. Or statutory authority, corporation, etc. Okay, whatever artificial people we can find. Okay, like we can find company, statutory authority, or corporations, etc. Okay, these are partner. These are individual entities. Okay, recognized by the law, though they are artificial. Plus individual, which is a real legal person. They can be a member of a partnership. They can be a they can be a partner of a partnership firm. Otherwise, not. Okay, so we have a proprietorship concern. Can this proprietorship concern be a partner in a partnership firm? Answer is no. Why? Because proprietorship concern is not recognized by the law as a separate entity. Proprietorship concern is known by its proprietor only. Whoever is a proprietor, he is the sole owner and sole responsible for the proprietorship concern. So he can be a member, but partnership concern because proprietorship concern, because it is not an artificial company, artificial association recognized by the law, it cannot be a partner in a partnership firm. Therefore, a firm, since it's not a person recognized in the eyes of law, cannot be a partner. A partnership firm too cannot be a partner in some other partnership. Okay, partners will have to individually become the partners of another partnership if they want to set up. They can set up any number of partnerships, but they cannot set up a subsequent partnership in the name of the joint partnership firm. That cannot be done. Why? Because partnership is not a legal recognized entity. Okay, it is separate. Sorry, it is not separate, it is just known by the faces, known by its people. Okay, that's it. It's partners. Again, a minor cannot be a partner in the firm because we are talking about the law. Law does not permit a minor to be a member or a partner of a company or a partnership firm. Minor, unsound, lunatic, or mentally unstable. Okay, these people cannot be. These cannot be partners. Okay, insolvent or bankrupt. Okay, these people cannot be partners in a partnership firm because they are prevented from entering into a contract. Okay, they are preventing from entering into a contract, and when they are prevented from entering into a contract, they cannot enter into a partnership. Why? Because the point number 2 says partnership must be a result of an agreement. Okay, agreement. They cannot be partners. Why? Because they are precluded from entering into a agreement. So can there be a person? Can a person who's lunatic sometimes and sound other times be a partner? Yes, because Contract Act says he could enter time of soundness of mind. When he is sound, he can take a decision regarding his agreement to enter into a partnership. Otherwise, not when he is laboring under a fit of epilepsy or lunatics, then he cannot do so. Okay, otherwise, when he is sound, if he is someone who's partially sound, partially unsound, when he is sound, he can enter into an agreement, otherwise, not. Agreement. It may be observed that partnership must be result of an agreement. Okay, between two or more persons. Partnership is result of an agreement between two or more persons. Like we discussed, there are at least two people because for agreement, okay, for agreement for the contract itself, we need two or more than two people. We cannot have an agreement or a contract where there are less than two number of people. Okay, individual cannot enter into a contract with himself because he himself cannot make a promise and he himself cannot accept the performance of the promise. Neither he can give consideration to himself. Okay, so an agreement, it has to be between two or more persons. There must be an agreement entered into by all the persons concerned. Okay, like if there are four people, all must have entered into agreement. Okay, otherwise not. This element relates to voluntary contractual nature of partnership. That means, okay, that means all the essentials of a valid agreement must be complied with when you are entering into a agreement to enter into a partnership. What are these essentials? They are like free consent has to be there, meeting of minds has to be there, capacity has to be there, consideration has to be there, proposal and acceptance has to be there. This element relates to voluntary contractual nature of partnership. Okay, that means the partnership has to be voluntary in nature. Okay, it cannot be a forced partnership. Partnership cannot be a forced partnership. Why? Because our constitution allows you freedom of association, which includes freedom not to associate. If you do not feel like associating with someone, no one can compel you to be an associate of that person. Okay, so you have to make a choice voluntarily, only you can enter into a partnership. Thus, the nature of partnership is voluntary and contractual. Okay, this is the core nature of partnership, that it is voluntary as well as it is contractual. There must be an agreement. Okay, it is just not that you are merely a employee. Voluntarily, you are an employee, and ultimately, because you are an employee, people will start calling you a partner. No, there has to be a contract and understanding of partnership as well. Mere voluntary will not help you. Mere voluntary, you may be an employee, okay, or you may be a co-owner, okay, or maybe a joint owner, but unless you have a contract for the partnership as well along with voluntariness, then only you will become a partnership. Mere voluntariness to associate with someone will not make you a partnership, okay, but there has to be voluntary association, plus association has to be a contractual association. Okay, what kind of contractual association? Let us see. An agreement from which relationship or partnership arises may be express. It may be express. Okay, we discussed agreement. We discussed agreements could be expressed, plus they could be implied as well as they could be inferred by the conduct. Same applies on the partnership. That means partnership could arise out of a express contract, which is expressly in writing. We are discussing issues, we are talking, okay, and sorting out the issues, but it could be implied as well. Okay, it could be implied, consent could be there, okay, and it could be by conduct as well. It could be by conduct as well. Implied means now there are four people, okay, four people, and one says let us four of all agree and set up a partnership. Then two are discussing the issues of partnership, the principles of the partnership between these four, and four are just sitting silently. They are not saying yes, they are not saying no. That means now they have become impliedly a member of partnership because it is being discussed in their presence, and when they put their funds, then they become impliedly a member of partnership. Okay, it may also be implied through the act done by the partners and from a consistent course of conduct being followed. Okay, whatever is the consistent practice they are trying to follow between them, it can show that whether the relationship is something else or it is a partnership. Okay, it may be oral or it may be writing. No requirement. No requirement of a written agreement. It could be oral as well. But advisable is to have a written agreement in order to take care of future contingencies which may occur, and there may be a issue between partners regarding those future contingencies, because orally we cannot take care of all the future contingencies, and any party may back off from anything, then the other party may find it difficult to prove the oral agreement, the factum of oral agreement. Therefore, it is always advisable that people should enter into a written partnership. When they are entering into a partnership, they should get a written partnership deed, otherwise they are going to face difficulties. Now the other point is business. Okay, the third element is business. In this context, we will consider two propositions. Okay, we will consider two propositions. First, there must exist a business. Okay, there must exist a business. What is business? Business simply means commerce. Okay, what is commerce? A commercial activity. What is a commercial activity? It is an activity carried out for profits. Okay, commercial activity is any activity. You carry out any activity. Okay, it may be a sale, purchase, it may be manufacturing, it may be retailing, it may be dealership, it may be anything, it may be services, it may be goods, it may be anything, but the activity, the gist of business. Okay, the gist of business is profits. Okay, if you are not interested into profits, your organization is going to be a charitable organization. If you are not interested into profits, the organization is going to be a charitable organization, and a charitable organization cannot be a partnership. Why? Because the act says partnership can only be one which is carried on for the which is carrying on business activities for profits. That means any activity which is bringing home some profits. It may bring home some loss as well, no issues, or it may bring home only losses. It won't relinquish its character of partnership simply because it is bringing on a lot of losses. Okay, but the intention was to carry on the profits. The intention was to bring home some profits. If the intention is only for charitable, only for doing charity, and people come along to do some charity, like we have some social organizations, okay, then it can be a political party, it can be a charitable organization, it can be a social organization, it can be a movement, but it cannot be a partnership, because gaining of profits, acquisition of gains is the gist of partnership. Profit is the gist of partnership. Okay. For the purpose, the term business includes every trade, occupation, or profession. It includes every trade, occupation, of profession. That means it includes goods as well as services. Okay, you are selling goods, manufacturing goods, producing goods, distributing those goods, or you are creating services and distributing or selling those, providing those services. It may be anything, it may be a trade, occupation, or profession. Okay, the existence of business is essential. The existence of business is essential. And now, what is business? Again, we come to business is equal to commerce. Commerce is equal to a commercial activity. A commercial activity is equal to an activity carried out for profits. Business means profits. Okay, it may mean losses as well, but initial understanding, but the nature of the activity, the ultimate end, ultimate goal of the activity is to carry it for profits. It may be bringing losses only, or it may ultimately bring losses and nothing else, but the original intention, we have to see the original intention was for business only, for profits only. Okay, though it may not 12 o'clock fulfill, that is a different issue. The existence of business is essential. Secondly, the motive of business is the acquisition of gains, like we just discussed, is for profits, which leads to the formation of a partnership. This intention, okay, now, secondly, the motive of business is the acquisition of gains, which leads to the formation of partnership. That means, first occurred a desire for profits, then came partnership. Okay, it is not that you enter into a partnership first, then you think about making profits. No, first there should be a desire for making profits. When you will have a common desire, when two or more people will have a common desire of making profits, and then they will come together, then only a partnership can come into existence. It is not that they enter into a partnership, doesn't know what to do and when to do and how to do. Later on they thought that let us do it for the profits. That partnership will not be a perfect partnership, it may be some other activity, but will not be a partnership. It means desire for gaining profits is very much relevant, very the very gist of the partnership. Okay, otherwise it's going to be a social or a charitable organization. Therefore there can be no partnership where there is no intention to carry on the business and to share the profits. Okay, share the profits. Agreement to share profits. The sharing of profits is an essential feature of partnership. Okay, the sharing of profits is an essential feature of partnership. Now when we are having profits, okay, then we all must distribute the profits as well, isn't it? Only one partner cannot have all the profit. If he is having all the profit, if all the partners are taking a fixed income and only one partner alone is keeping all the profits, the activity will not be a partnership. What will this activity will be? It will be an employment. It will be an employment. Other will be salaried officers, salaried employees of the employer. Who is the employer? The partner who's taking all the partnership profits. Okay, so it is a key aspect that profits must be shared between all partners. Now, what is the ratio of sharing profits? Okay, what is the ratio of sharing profits? They may there may be five partners. One is taking 99.2% share in profit. Other five, other four are taking others are taking 0.8% share. What is the left after 99.2% is deducted from the 100 and divide 0.8% by 4 because there are 4 people that are taking this percent of the share. Now, companies earning 100 crore. Out of those 100 crore, one alone is taking 99 lakh rupees, 99 lakh rupees and 20,000. Okay, 99 lakh rupees, 20,000 rupees. Rest 4 people are taking only 20,000 each. Will that be a partnership? The answer is yes. It still will be a partnership. The gist of the partnership is the sharing of profits and sharing of the same. Okay, the gist is not the proportion that you should equally take. It is not mandatory. It is not mandatory to equally share profits between all partners. Okay, it is not mandatory at all. The profit sharing ratio could be anything. It could be any ratio. It could be 25, 25, 25 or 75, 25 or whatever. Okay, or it could be this as well. Okay. The sharing of profits is an essential feature of partnership. There can be no partnership where only one of the partners is entitled to all of the profits of the business. Partners must agree to share the profits in any manner they choose. Any manner they choose, okay? If there can be no partnership where only one of the partners is entitled to the whole of the profits of the business, then it will become a employment. Okay, it will become a employment, not a partnership. But an agreement to share losses is not an essential element. Okay, agreement to share. Agreement to share loss is not essential to a partnership. Therefore, if out of five, only one partner is sharing all the losses, it is perfectly okay. It is perfectly okay. We do not discuss about sharing of losses. Okay, we discuss only about profits. The activity is being carried out for the profit making. There may be some losses during the activity, but the law is least bothered about the losses. What the law is concerned about is sharing of profits alone. So losses may be shared only and only by one partner out of five, and he is only facing all the losses, all others are not taking any share in the loss. Then also it shall continue to be a partnership till the time it arises out of an agreement for carrying out a business activity and sharing of profits among all. The profit sharing ratio may be anything. We are not concerned about the ideal profit sharing ratio at all. But an agreement to share losses is not an essential element. It is open to one or more partners to agree to share all the losses. It is open, okay, they may agree to share all the losses. However, in the event of losses, unless agreed otherwise, there must be borne in the profit sharing ratio. However, in the event of loss, suppose a loss happens, and if there is no prior agreement to share loss, then it shall be as per the profit sharing ratio. Okay, if there is no prior agreement to share the losses between the partners, okay, and some loss has occurred, now how will they share the losses between themselves? They'll share the losses between themselves by way of the profit sharing ratio. Whatever profit sharing they have, they will apply it on the loss sharing as well. Okay, in the event of absence of the contract. Let's do the example. Co-owners who share among themselves the rent derived from a piece of land are not partners because there does not exist any partnership business. A has a commercial building. Okay, A has a commercial building. A dies. A dies leaving behind two sons B and C. Now these B and C have become co-owners. Now this commercial building and sharing the rent equally among themselves. Now they are carrying on a profit activity and they are sharing the profits as well. Now will we call this activity as a partnership activity? Partnership activity, the answer is this is not a partnership. This is not a partnership, but because this is a legal succession, legal application, legal rule of succession of the property of a father, predeceased father by his son. So they have merely become owners of the property as the father has died, leaving them equal share. Now they are just sharing the rents. Okay, we cannot say they are carrying on a activity here with the intention to share profits. Okay, they are merely, it is a status that they are son of that person who had ownership over this particular building. Now they are co-owners. They are merely co-owners and nothing else. They are merely co-owners or joint owners. Okay, nothing else. This will not be a partnership. Example 2 says, no charitable institution or club may be floated in partnership. A joint stock company may, however, be floated for non-economic purposes. Charitable institution, like we discussed, business is the gist of partnership. So, a charitable institution cannot be a partnership, or a club. Club cannot be a partnership at all. Let us go back to other relationship which we thought we will discuss. Now, a joint stock company. Now we have done something about partnership. Okay, we have done something about partnership. We have read some of the essentials of the partnership. Let us now understand, is it, what is a joint stock company? Joint stock company is a company. Okay, simply joint stock company okay, hence it can be a partnership. They are holding the stock together and selling it. That's a company. It is not a partnership. What is club? Club is a non-profit activity for members. Non-profit activity or services for the members. Like we have some club, suppose say residents association club. Okay, there is a residential society in which each is to deposit 100 rupees per month. Okay, and then the club is organizing some swimming pool facilities are there, or the games facilities, or a canteen is there where products are sold to you on non-profit basis. Okay, suppose you are getting a chips packet outside 10 rupees, but club is selling you at 9 rupees, which is the purchase price. Okay, they are not making any profit, they are sharing, selling it for the benefit of members. Okay, it is for the benefit of members only, not a commercial activity. Club is not a commercial activity. Club is only for the mutual benefit of members. They are providing services, mutual benefit of members. Okay, it is not a commercial activity. Plus no member can claim share in profits of club. If club has made some earning, no member can claim any shareholding in profits of club. No, it will belong to the club and club will decide. Okay, but whatever club will do, club will definitely do it only for the benefit of all the members, not only one member. Okay, so club is not a partnership. Then there is Hindu undivided family. Hindu undivided family. Okay, now activity is being carried out by Hindu undivided family, family members, and sharing the profit within themselves. Within themselves. Now, is this a partnership? They are carrying out professional activities. Hindu undivided family is carrying out a professional activity, and they are earning profits as well, and they are distributing profits among themselves. Now, do we call it a partnership? Do we call it a partnership? HUF will not be a partnership because of two reasons. Okay, because of two reasons. Because number one is there is no agreement at all. By birth, you automatically become part of HUF. By birth alone, you become a part of HUF. There is no such agreement between you and the other partners, okay, to have you in the partnership or not. By birth, you become a member of HUF, okay. So it is not a partnership firm, because partnership arises only out of an agreement. Like we discussed, first there will be a desire for earning profit, and then there will be an agreement. Here, there is no agreement at all. People are entering into relationship with each other simply because of their birth in a particular family. Plus, share is already defined. The share in the profit is already defined even before they are entering into the partnership. Their activity, family activity, their share is defined by the share held by the father. They cannot add or reduce their share. Okay, so you totally have no control as a partner, okay, in the HUF. So you you do not call HUF as a partnership, because there is no agreement at all. Co-ownership, we have discussed. Okay, we have discussed co-ownership. Co-ownership, simply co-ownership, without an intention to carry on a commercial activity and sharing of profits. Simple co-ownership, like we discussed a case of two brothers who succeeded their father, and father left some property. Simply co-ownership. It will not be a partnership. It may be that father had a commercial building. Okay, two sons succeeded it. Now they both decided to convert it into a hotel and put some funds into such conversion, and then share the profits earned by such hotel. Then it will become a partnership. Then it will become a partnership. Why? Because they are not only co-owners, but now they have become partners. They are pooling funds. They are distributing things. They have set up an agreement for a separate thing and for a separate activity, and to share the profits out of that activity. But merely because you become co-owners, like two brothers, okay, you are co-owning the property owned by your father, you will not become partners. Okay, you are not partners, you are still individuals, just owning the share in the profits arranged by that particular commercial activity. Okay, you are just co-owners. Versus the association. Association. Association itself is a very vague word, very vague and a very confusing word, because co-ownership is also an association, HUF is also an association, club is also association, joint stock company is also association, a company is also association, and a partnership is also an association. So what are we talking about? Association is a very broad term which encompasses all these features. So association is a very confusing term. So any association will not become partnership. Only those association which are which are carrying out business activity with the intention to share the profit among all of them. Okay, and there is an agreement for that fact, only that association will become partnership. Every association is not a partnership. Okay, there may be any associations, any number of associations like we discussed, but every association will not simply become a partnership at all. Now let us do example 3. X and Y buy certain bales of cotton, which they agree to sell on their joint account and to share the profits equally. In these circumstances, X and Y are partners in respect of such cotton business. Okay, now this is a partnership. because what they did, they buy certain bales of cotton and they agree. There is an agreement. There is an agreement, plus agreement is to sell. Okay, agreement is to sell. When they are selling something, anyone would sell usually something on the with the hope of making some profit. Nobody sells something thinking that he wants losses only. So when someone is selling something, that means definitely he is hoping to make some profits, and there is an agreement to sell between X and Y on their joint account, and to share the profits equally. They are sharing that there's a profit sharing as well. So in these circumstances, X and Y are partners in such cotton business. Okay, now they have become partners in such cotton business. Okay, so that is a example of partnership. Business carried on by all or any one of them acting for all. Now, what is the decision making of a partnership firm? Okay, there are five members. They all may decide that we all will participate in the business activity and we all will take decisions collectively. Or they all may say, for the smoothness of business, for the efficiency of the business, one may be one who is more sharp, or people have a high belief in that person, or who's an expert in that particular kind of business, that we all may we all may give these powers to one person only. We have delegated this power to one person only, and he will be, we can call him a managing partner, like we have a managing director in the company, so we can call him a managing partner, that he will take all the decisions, and whatever he will decide, we all will follow it. Okay, then also it is okay, because partnership act does not say that you have to take the decisions as well collectively. Okay, there has to be share in the profits. You have to take share in the profits, but share in the business activity, share in decision making, sorry, I should say, is not mandatory. It is not mandatory that all must equally arrive at some decisions in the partnership. No, it may be by majority. It may be 3 to 2. Two partners may be against it and three may be in favor of it. Then the majority rule will win. All have not agreed here. Okay, all have not agreed here. Only three have agreed. So by majority, the decision will be taken, and we cannot say that because two people are not agreeing to particular decision of the partnership, it will not be a partnership at all. No, it will continue to be a partnership. Decision making has nothing to do with the partnership. Gist of partnership. Okay, gist of partnership. I again tell you, it is agreement plus to share profits. That's it. Okay, and it is not mandatory that who is acting on behalf of them. Either all of them are acting for the partnership, or only one of them is acting for the partnership. Okay, so it is not mandatory. Any one of them can be acting partner for all of them. The business must be carried on by all of the partners, or by anyone, or more of the partners acting for all. Like out of these five, all five may be acting, or only one, anyone, or more of the partners, or two or three may be continuing business, another two may be just sitting members or sleeping members. They are just earning profits and sharing losses. That's it, nothing else. They are not taking part in any decision making of the business. Sufficient, no issues. Okay, it may not be that other person should also have knowledge. Other person may not at all take part in the business. He may just take part into the losses and profits only. This is the cardinal principle of the partnership law. Okay. In other words, there should be a binding contract of mutual agency between the partners. Now, when we are saying that only one will take decisions for all the five people, then what are we trying to say here? Okay, what are we trying to say? We are saying all five are bound by a decision of one, isn't it? All five are bound by the decision of one. That means we are creating a mutual agency, a relationship of mutual agency. We are creating a mutual agency relationship between all. Okay, that means all members are liable towards fund, towards firm, sorry, liable towards firm as well as towards each other. Okay, meaning thereby, since they are partners, all are principal as well as all are agents. Okay, irrespective of the profit sharing. It may be that one alone is having 99% profit and the four people are having 1% sharing. Okay, all together are having only 1% share in the profits, but still they will continue to bind that one major shareholding partner as well. Okay, because partnership business, partners are principal as well as agent for each another. Okay, there is a mutual agency between the partnerships, between the partners. All are principals as well as all are agents. All can bind the partnership firm with their decision and thereby bind all the partners as well. The business carried the business must be carried on by all the partners or by any one or more of the partners acting for all. This is the cardinal principle of the partnership law. In other words, there should be a binding contract of mutual agency between partners. An act of one partner in the course of business of the firm is in fact an act of all the partners. Okay, this is the agency. This is a feature of mutual agency. What is a feature of mutual agency? Feature of mutual agency is an act of one partner in the course of business of the firm is in fact an act of the all partners. What one is doing, it is assumed that others are also doing that same thing. Each partner carrying on the business is the principal as well as an agent for all the other partners. Each partner carrying on business, okay? He is an agent insofar as he can bind the other partners by his acts, and he is principal to the extent that he is bound by the act of other partners. So, he is one partner is principal as well as agent, both in one person. But how? When he is binding other people by his actions, then he behaves like an agent here. And when he is being held bound by the activities of other partners, then in that case he is acting like a principal. Okay, because principal is bound by the act of agent. So when he is being bound by somebody else's act, he is an agent. Okay, and when he is binding others people, then he is acting as agent. Okay, in earlier case as a principal. It may be noted that true test of partnership is mutual agency rather than sharing of profits. Okay, mutual agency is the other important element of partnership. Okay, if the element of mutual agency is absent, then there will be no partnership, because when there is no mutual agency, that means there is no agreement to bind each other. When there is no agreement to bind each other, what would it be? It would be a Hindu unwed family or co-ownership. Sorry, it will be a co-ownership. It will be a merely some association for profit or a co-ownership. If you are not individually binding each other, holding yourself each other responsible for the acts of others, okay, it will be merely a co-ownership or joint ownership if you are not having any mutual agency. So this, here we get another essential of a partnership, that there must be a mutual element of mutual agency. If you are binding each other, if you are not binding each other by your activities, then partnership definitely cannot survive. It will be very difficult for the partnership to survive. It may be a co-ownership, or it may be some association for profit, or something else. It may be a club, or whatever it may be, but it will cease to be a partnership the moment you take out the element of profit, or you take out the element of mutual agency, element of acting on behalf of each other, because the act says it, that acting, that business carried on by all, or any one of them acting for all. This is what we are doing. We are just trying to break down, declassify the definition of the partnership, and we are trying to understand it in this manner, in piecemeal manner, okay, because that is the best way of understanding something. Let us take a 2 minutes break, and I'll catch up with you people within 2 minutes. It's a water break. You also take water, I'll also take water. Now let us do a very famous case law on the subject. Okay, this is the case law of K.D. Kamath and company. I will discuss the brief facts with you people. Okay, these are the brief facts of the case. K.D. Kamath entered into an agreement. He had a proprietorship concern where he had 4 employees. Later on, he thought that let us transfer this proprietorship into a partnership. What he did, he entered into an agreement with his 4 employees. Now he said, from today you will become partners. Now we all five are partners. I will have around 90% share in the profit, and I alone shall take decisions regarding partnership. I alone shall operate the bank account of the firm. I alone shall sign the checks. I alone shall be able to bind the firm by my decisions and not other partners. Okay. These were the terms and conditions he put into writing with all the partners, and all partners agreed. Now there was a dispute regarding some tax structure. Some taxation issue was there, and it was a issue whether this is a partnership or not. Okay, whether we can call this kind of a relationship a partnership or not, where KD Kamath is the whole and soul of the face of the partnership. He is doing whatever he wants to. He will only sign the checks, only he will operate the bank account. He alone will bind the firm and the other partners. He is only alone. He is able to bind the rest four with his acts, but rest four cannot do anything without the permission of the KD Kamath. Okay, they do not have any personal decision making power. Will this be called a partnership? Then what the Supreme Court held? The Supreme Court has held that two essential conditions have to be satisfied. Supreme Court has now further delimited these five essentials to two essentials. Okay, he said, so sorry, not he, it, Supreme Court stated there should be an agreement to share profits as well as the losses of business. Okay, now there is there an agreement in this KD common to share profits and losses? Yes, there is an agreement to share profit, 90% profit as well as losses. Okay, because even when there is no agreement to share the losses, then the loss sharing will be as per the profit ratio. So definitely the 90% loss will be suffered by Kamath, and the rest will be distributed as 10% between all four jointly. So yes, there is an agreement to share profit as well as agreement to share losses. The business must be carried on by all or any one of them acting for all within the meaning of definition partnership. Now, in this case, business is carried on by any one of them acting for all. Now, KD Kamath says, I will act for all of you people, and they agree. Okay, now there is a decision that all will enter into a partnership, and only one, that is KD Kamath, probably because of his superior skills of the business. Okay, that he will take decisions. Business will be carried out by any one of them. Is it happening here? Yes, it is happening here. So, will this relationship be a partnership or not? Supreme Court held that it was a partnership indeed. Supreme Court held that this relationship satisfied the two tests of the partnerships: sharing of profits plus business being carried out by all over any one of them on behalf of all. So it is satisfied here. It is immaterial who's operating the bank account, who's signing the check, or who's acting on all of them. But if they all have decided to be bound by the act of one, then it will be a mutual agency. And when there's a mutual agency plus sharing of profit, it will be a partnership. It will be a partnership. The fact that exclusive power and control by agreement of the parties is vested in one partner. Okay, the fact that exclusive power and control here, the exclusive power and control is given to one KD Kamath by agreement of parties. By agreement of the parties is vested in one partner. Who's one partner? One partner is KD Kamath here. Okay, all the control and power is vested in KD Kamath. Or the further circumstance that only one partner can operate the bank accounts. Only one partner, that is KD Kamath, can operate the bank accounts or borrow on behalf of firm, or only he can take loan. Only he alone can take loans for the firm. Are not destructive of the theory of partnership, provided the two essential conditions mentioned earlier are satisfied. Okay, that means only these two conditions have to be satisfied. Whatever else is the relation between partners will not destruct the theory of partnership. Okay, it's not destructive. It will not it will not stop the mutual agency. It will not stop the element of partnership between them. So Supreme Court held that indeed it was a partnership firm. Okay. Now you understand the true test of partnership, and we will discuss it within 1 minute or two. You read it meanwhile. Mode of determining existence of partnership. Section 6 says, how do you determine whether there is a partnership between people or not? In determining whether a group of persons is or is not a firm, or whether a person is or not a partner in a firm, regard shall be had to the real relation between the parties, as shown by all relevant facts. Regard shall be had to the real relation between the parties. Okay. The key factor is, this is the key factor. True test is, whatever you people may have written on a partnership deed, whatever may be written or agreed, but the true test is whatever is a real relation. You may have agreed to anything, you may have written anything, but whether you are really following it or not, what is the real relation between partners? That is the true determining factor between the true test of a partnership. For determining the existence of partnership, it must be proved. There was an agreement between all the partners, all the persons concerned. It has to be proved that there was an agreement, okay, like we discussed. Then it has to be proved that that agreement was for sharing of profit. And the business was carried on by all or anyone acting for all. Acting for all is a key word again. Acting for all means acting for all shows the existence of mutual agency. Okay, if you are not acting for all, then it is not a partnership. If you are acting only for yourself, then it is not a partnership. Like in the case of co-owners, everyone is acting for themselves. No one is acting for the other person. Okay, but they are co-owning a business. That's it. They are not partners. That is simply a business association, which is not a partnership. Partnership is created by agreement and by status. The relation of partnership arises from contract and not from status. So the partnership is created by agreement and not by status. Okay, not by status and not from status. And in particular, the members of Hindu undivided family carrying on a family business as such, or a Burmese Buddhist husband and wife carrying on business as such, are not partners in such business. Why? Because the members of Hindu undivided family are member because of status. Okay, what is the status? Status here is taking birth in the family. I have taken birth in Ambani's family. Okay, I'll share his wealth. That's it. This is not an agreement between me and my father. There is no agreement between me and my father. There is a status that he is my father and I am his son. That is the status, and I become part of the Hindu undivided family. And I enjoy the wealth, or even I share the responsibility or burden of losses as well. No issues. But I have no agreement at all. So when there is no agreement, there is an existence of mutual agencies also there in the Hindu undivided family. Whatever karta, whatever is the manager of the Hindu undivided family will do is binding on the other partners, other members of the Hindu undivided family. But that is not happening because of a contract, because of an agreement. That is happening because we are part of that family. So a family stays together. So when we are a part of family, we are not in a partnership. That is not a partnership. Only when people come together out of an agreement, they can set up a partnership, otherwise not. Sharing of profit. The sharing of profits or gross returns arising from the property by persons holding a joint or common interest in that property does not itself make such persons partner. Merely sharing of profit will not make people partners. Okay, merely sharing of profits. Like the case of co-owners or joint owners. Merely sharing of partner profits will not become a partnership. Or let us take a case of A takes a loan. A says, I want to carry out a commercial activity and I'll make profit, but for that I need funds. So what he does, he approaches bank and takes a loan. Bank passes the loan and bank will take an interest over the loan. Okay, so now he makes the profit, he enjoys the profit, and out of that profit, he repays the bank loan as well. So bank is also earning a profit, he is also earning a profit from the same activity. But will they become partners? No, they are simply sharing the profits. They are not partners at all. Okay, they both are not even sharing the profit, they both are making the profit. He is making his own profit, bank is making its own profit, but they will not become partners at all. Okay, they are not partners at all. The receipt by a person of a share of the profits of a business or of a payment contingent upon earning of profits or varying with the profits earned by a business does not itself make him a partner with the persons carrying on the business, and in particular the receipt of such share or payment. Or let us say, let's have another example. A is having a okay. A is having a commercial building. His tenant, suppose McDonald's, takes the premises on rent, and the McDonald's say, I'll give you 10% share in the profits as rent. Whatever profit I earn by working at your place, by using your place, 10% of it I'll give it to you. It may be 10 lakh, it may be 1 lakh, it may be 1 crore, it may be 50,000, it may be anything. I'll give it to you as a rent. He agrees. Okay, so now the profits are dependent upon the earning is dependent contingent upon the earning of profit. The earning of A is contingent means dependent upon the earning of B, earning of tenant. Whatever A will earn, what A will earn will depend upon the earning of B, that is his tenant. So A is dependent upon the earning of tenant now. Okay, so tenant will give him 10% of the share. If tenant is not making any profit, tenant will not pay anything. If tenant will make the profit, tenant will pay him 10%. Will that become a partnership? No, this is not a partnership. Why? Because there is an agreement here. Okay, agreement is there. They both have entered into agreement. Agreement is to share of profit. Profit they are sharing. But there is no mutual agency. Okay, whatever commercial decisions tenant will take, he definitely cannot bind the landlord by it. So landlord is not bound by the decisions tenant takes, but he is only entitled to take 10% profit from the activity carried on by the tenant. Therefore, when there is no mutual agency, and we have discussed the case of KD Kamath where Supreme Court says the true test lies in the mutual agency. When there is no mutual agency, when they both are not acting for each other, then there is no existence of partnership between these two people at all. These are the examples. By a lender of money to persons engaged or about to engage in any business. Okay. By a servant or agent as remuneration. I have a servant or I have an agent, but I give him only remuneration. I give him salary. Remuneration is salary, not a share in the profits. That is my salaried employee, not a partner. Salary, okay, not profit sharing. Buy a widow or child of a deceased partner as annuity. There was a partner in the firm, now he has died. Okay, and the partnership firm is paying annuity. Annuity means annual payments. Annual payments for the maintenance of the wife, for the widow or the child. That is not partnership. This will not become a partnership. This is merely payment. By a previous owner or part owner of the business as a consideration for the sale of the goodwill or the share thereof does not itself make the receiver a partner with the person carrying on the business. Okay, they are co-owners, okay, or co-sharers of profit. That's it. They are not having any mutual agency. They cannot bind each other, neither are they acting for the each other. So there is no partnership in these businesses models at all. They are different business models. We can put them as a business association or a profit sharing association, but definitely we cannot qualify them as a partnership. As discussed earlier, sharing of profit is an essential element to constitute a partnership. But it is only a prima facie evidence and not a conclusive evidence. Okay, it is only a prima facie evidence and not a conclusive evidence. Sharing of profit is essential element to partnership. It's a prima facie. That means it appears so. Prima facie means it appears. It appears that when they are sharing profits, they are having a partnership, but it's not a conclusive evidence. Conclusive means something which proves. Conclusive means something which settles the doubt finally. So it is not a conclusive evidence. It cannot merely sharing of profit cannot settle the doubt of partnership finally. The doubt of partnership finally will be settled only when there is a mutual agency, when they are acting on behalf of each other. That's it. In this regard, the sharing of profits or of the gross returns accruing from the property by persons holding joint or common interest in the property would not by itself make such persons partners. Okay, merely by sharing or co-owning or jointly owning will not make each other a partner at all. Although the right to participate in profits is a strong test of partnership, it's a very strong test of partnership, like we discussed. And there may be cases where, upon a simple participation in profits, there is a partnership. There may be cases where simply because you enter into a profit sharing, you become a partner. And there may be cases where, upon a simple partnership in profits, there is a partnership, yet whether the relationship does or does not exist must depend on the whole contract between the parties. Whether the relationship is partnership, because this is the partnership is the name of that relation. Whether the relation does or does not exist must depend upon the whole contract between the parties. We cannot simply read the profit sharing agreement and come to the conclusion that these people are partners. We'll have to read the contract as a whole, and we'll have to check the different points of the contract in order to understand whether this is a partnership or not. Where there is an express agreement between partners to share the profit of a business and the business is being carried on by all of them or any one of them acting for all, there will be no difficulty in the light of provisions of Section 4 in determining the existence or otherwise partnership, just like in the case of KD Kamath. There is no difficulty in understanding when there are two things: sharing of profits plus mutual agency acting together, or any one of them acting for all. This is also another very essential part. If this is not there, merely profit sharing will not make you a partner in the partnership firm. But the task becomes difficult when either there is no specific agreement task becomes difficult when there is no specific agreement, when only an oral agreement is there. Okay, no specific agreement means only an oral agreement. No agreement by conduct is there. That is why I said that it is advisable to always have a partnership deed. That means a written partnership agreement between partners, because it will be difficult to prove the oral agreement or the implied agreements or the agreement by conduct. It will be very difficult. Or the agreement in such as does not specifically speak of partnership. Where the agreement does not talk about partnership, it will be difficult to understand whether it's a partnership or not. It will depend upon the context of the contract as a whole. In such a case, for testing the existence or otherwise of partnership relation, section 6 has to be referred. We have to refer to section 6. What is section 6? This is section 6. Mode of determining the existence of partnership. Okay, agreement, sharing of profit, and mutual agency. This is the section 6. Then we'll have to refer this section 6 in order to understand whether it's a partnership or not. According to section 6, regard must be had to the real relation between the parties as shown by all the relevant facts taken together. We must give the regard to all the relevant facts taken together. The rule is easily stated and is clear, but its application is difficult. Okay, rule is easy to understand, but the application is difficult. Cumulative effect of all the relevant facts, such as written or verbal agreement, real intention, the conduct of the parties, other surrounding circumstances, etc. Everything we'll have to take into consideration while determining when there's a ambiguity, when there's a dispute or a doubt whether this is a partnership or not. What do we have to? How do we determine it? We will see the written agreement or the verbal agreement, or the what is the real intention, the conduct of the parties, and other surrounding circumstances, how they are actually behaving, are they binding each other or not. All we'll have to take into consideration, okay, are to be considered while deciding that the relationship between the parties and ascertaining the existence of partnership. Whether there's a partnership or not, we'll have to look into all the surrounding circumstances simply by one circumstance, that they are binding each other, or simply by saying that no, they are sharing profits. This is a partnership. No, it is not the true test of determining the partnership. True test is given in the definition and then further clarified in the section 6 that we have just discussed, which is mode of determining the partnership. Excuse me. Agency. Existing of mutual agency, which is the cardinal principle of partnership law, is very much helpful in reaching a conclusion in this regard. Each partner carrying on the business is the principal as well as an agent of the other partner, like we have discussed. So the act of one partner done on behalf of the firm binds all the partners, because firm has no individual face. Firm is the what is the face of the firm? All the partners are the face of the firm. Firm has no individual face. So when you will bind the firm, you will bind all the partners. If the element of mutual agency relationship exists between the parties consisting a group formed with a view to earn profits by running a business, a partnership may be deemed to exist. We will understand that there exists a partnership, otherwise not. Existence of mutual agency, which is the cardinal principle of partnership law, is very much helpful in reaching a conclusion in this regard. Each partner carrying on the business is the principal as well as an agent of the other partners. Each partner is principal as well as an agent, as we have already discussed. So the act of one partner done on the behalf of firm binds all the partners. If the elements of mutual agency relationship exist between the parties constituting a group formed with a view of earned profit running a business, the partnership may be deemed to exist. Sorry, this is a repetition. I must remove it from here. Shanti Ranjan Das Gupta. Shanti Ranjan Das Gupta versus Dasaran Muzamul. Okay, this is the case in which Supreme Court decided following things. Shanti Ranjan Das Gupta versus Dasaran Muzamul is the name of the case. These are the parties. In Shantiranjan Das Gupta versus Desai and Muzamil, following factors weighed upon the Supreme Court to reach the conclusion that there is no partnership between the parties. Supreme Court came to the conclusion that this relationship was not a partnership at all. Okay. Okay. Now, for deciding such, what were the factors which were taken into consideration by the Supreme Court for deciding so? Let us read them. First one is parties have not retained any record of the terms and conditions of the partnership. Okay, that means it was based on a oral understanding. It was based upon an oral understanding. There was no written partnership deed. When the partnership deed, you do not have a partnership deed, it becomes very difficult to prove the oral understanding, especially because understanding exists in the mind. So proving something on the record that some understanding existed in the mind, what exists in your mind, it is difficult to prove. Okay. Partnership business has maintained no accounts of its own, which would be open to inspection by both the parties. Now, this partnership business is not having a separate bank account. No separate bank account in the name of firm, no separate work ledger or the business ledger in the name of firm. What they were having in this case, both parties were having their own individual accounts. That's it, their own individual firm, their own individual records. They did not have any joint record at all for the partnership. So it is very difficult to understand that they acted in partnership with each other when they are not having any common thing, no common account, no common work ledger, no business work ledger jointly. Okay. Neither neither was the parties entitled to inspect neither the parties were entitled to inspect the accounts maintained by the other. This is very crucial here because in a partnership firms, all partners are entitled to inspect the records because essentially the partnership is based upon the profit sharing. So when you are talking about profit sharing in business, definitely you should know how much profit is made or how much amount is spent. How do you know about the amount spent or the profit made? Only because of when you will have the access to accounts, when you can inspect the accounts of the firm, only then you will can get to know. But in this case, neither party had any access to accounts maintained by each other individually. There were no account for the firm at all. Individually they are maintaining accounts, plus no one was allowed to inspect the accounts of other. No account of partnership was opened with any bank. There was no separate account like we just discussed here. No written intimation was conveyed to the deputy director of the procurement with respect of the newly created partnership. Okay. They procured something from this deputy director of procurement. This is a government officer. They both acted as a partnership and procured something from deputy director, but the procurement was made in the individual names. This procurement too was never made in the name of the partnership. Okay. So merely the people were sharing profits. They were sharing profits. But based upon all these things, Supreme Court said there does not exist. There does not exist mutual agency. When there is no mutual agency, then there is no partnership at all. So this is how you determine whether there is a partnership or not. In the case of KD Kamath, how it was decided. In the case of this Shanti Ranjan Dasgupta, how it came to be decided that this is not a partnership. This is for all you to understand now. Partnership distinguished from other forms of organization. Okay, other forms of organization. Let's follow this tabular pattern. First is on the basis, we are distinguishing on the basis. First is legal status. Partnership. A firm is not legal entity. It has no legal personality distinct from the personalities of its constituent members. Partnership firm has no legal entity like we discussed. It's not a artificial person. It is known by the its members only. The face of the partnership is the face of partners. That's it. Company has no, or this partnership has no face of its own. A company is a separate legal entity distinct from its members. Solomon versus Solomon we have discussed in the when we are discussing the case of when we are discussing companies law, we discuss this case law Solomon versus Solomon, in which the English court held that a company is separate from its members. Company has its own separate face, but it is not the case of partnership firm. Partnership firm does not have its separate face or the separate entity. Agency. In a firm, every partner is the agent of the other partner as well as the firm. Okay, we are principal as well as agents in a partnership firm. But in the joint stock company, in a company, member is not an agent of the other members or the company. His actions do not bind each other. Okay, company people are member, but they are not agents. Okay, like we discussed, there is no mutual agency between a company. Company has its own legal entity, so company will decide for itself. No member can bind the company by its own actions. Okay, see, you people do not have to be confused here by the word joint stock company. This is just the name of the company used to be, which was used in the earlier times. Company was known as a joint stock company. Now we know it only a company. Now we see it only as a company. Earlier we used to see it a joint stock company where people are having jointly holding a stake. Okay, but now we call it on a company. So joint stock company is just a ancient name or a antique name of a company. So don't be confused about what this joint stock company is. Joint stock company is just like any other private company. Okay. See, many times this may be asked in the examination, that you lay out the differences between or distinction between a joint stock company or a company and a partnership. Then you will have to refer to this table and you will have to answer accordingly. Okay, and because in your CA syllabus questions are not MCQs, you do not really get many MCQs. Okay, multiple choice questions. You are asked descriptive answers where you have to describe, where you have to write, where you have to express. Okay, so you will have to express it in this kind of manner. Okay, so next basis of differentiation is distribution of profit. In a partnership firm, the profits of the firm must be distributed among the partners according to the terms of partnership deed. Must. Okay, that means they have to be distributed in any case. Partnership firm cannot retain the profits up to itself. It has to distribute the firms. It has to distribute the profit between the partnership as per the partnership agreement. Now, in the case of a company, there is no such compulsion to distribute its profit among its members. Some portion of the profit, but generally not the entire profit, become distributable among the shareholders only when dividends are declared. Okay, companies usually declare dividends, but they do not declare dividend of the 100% of the profit. Company retains some of the profit with itself and distributes profits on the other part between the members or the shareholders, but company cannot be made liable for declaring dividends. Okay, company may be making profits, but company is not entitled to distribute dividends to its shareholders. There is no compulsion if the company does so. It's a gracious act of the company. It's a gracious act of the company, not a compulsion upon the company. Extent of liability. In a partnership, the liability of partners is unlimited. This means that each partner is liable for debts of a firm incurred in the course of business of the firm, and these debts can be recovered from his private property if the joint estate is insufficient to meet them wholly. In a company limited by shares, the liability of shareholder is limited to the amount, if any, unpaid on a share. But in the case of guarantee company, the liability is limited to the amount for which he has agreed to be liable. However, there may be companies with the liability of members unlimited, but we usually do not see unlimited liability companies at all, because companies meant only for creating the limited liability thing between the partners, so between the members. So this is a major difference between a partnership and a company. In a partnership, the liability of a partner is always and always unlimited one. Okay, unless it's a limited liability partnership, which we will discuss later on. But a partnership which is a normal partnership, it is always unlimited liability. If the partnership firm is unable to meet the liability, then the private property of the members, then the private property of the partners is also liable. Their own house, their cars, their valuables can be sold off for the debts of the partnership firm, for discharging the liabilities of the partnership firm. Why? Because we are agent as well as principal of the firm. Okay, but the company is limited by shares or the limited by guarantee or unlimited company, like we have discussed. Companies different types. Usually, and in most circumstances, and when I say most circumstances, I say 99% cases, companies always having a limited liability. The personal estate of the shareholder or a member of the company is never liable to the actions of the company. If the company is not able to discharge its liabilities, company will simply liquidate itself. It will go into bankruptcy, but it cannot definitely take the private property of its members. Property. The firm's property is that which is the joint estate of all the partners, as distinguished from the separate estate of any of them, and it does not belong to the body distinct from the its members. But in the case of joint stock company, in a company, its property is separate from that of members, who can receive it back only from the in the form of dividends or refund of capital. Okay, this is another distinguishing feature between a partnership and a company. A company in a partnership, the property of a partnership firm is a joint property, jointly owned property. All of them are the owners, all are co-owners of that property. Okay, so when the partnership firm is liquidated, they will sell off the assets of the partnership firm and will equally take, or as per the decision between the partners, they will take the property of the partnership. Okay, they own the property. Virtually, they are the owners. Legally, also, they are the owners of the partnership firm. But in the case of company, no member is the owner of the company or the company's property. Property, because it's a separate legal entity, it can have its own property in its own name. It can get the registry done. It can make the sale, purchase, and it can be sued and do whatever it wants to do. But in the case of a partnership firm, because partnership firm is not a separate legal entity, so it cannot have a separate property from its members at all. It cannot have a separate property from its members. Transfer of shares. A share in a share in partnership cannot be transferred without the consent of all the partners because partnership has a distinct nature. Okay, it depends upon the mutual agency, mutual relation, mutual knowledge about partners. Okay, you cannot transfer your share. A partner cannot transfer a share, and if he transfers the share, the partnership will automatically come to an end. Okay, the partnership is a very delicate relation. If you transfer the share, okay, it's just a relation. Like I have a relation with my brother. Can I transfer this relationship or brothership to someone else? I cannot. Okay. Can I transfer my relationship between my father and me to someone else? Can I call someone else my father? No, but yes, I can do legally if my father gives the permission and I am being adopted by someone else and he also adopts me with the permission of my father, then I can legally be adopted by someone else and I will then become his son. But similar is the case with the partnership firm. If all the co-partners unanimously they give a consent, even if one partner says no, you cannot sell your share, then you cannot sell your share. That's it. So transfer of share is there, but it is very much restricted, very very heavily restricted. Okay, otherwise not easy. Similar in the case of company, transfer of share is very easy. Okay, very easy. It is just subject to some restrictions by the articles. In the case of a private company, some restrictions are there. Like we have discussed, some restrictions may be there, but still transfer of share is allowed. You do not need someone's permission, you only need to comply with the articles. And in the case of a public company, you can freely transfer shares. It is highly liquid, freely you can transfer shares at your will whenever you want to. Okay, in the partnership firm, in the company. The management, in the absence of an express agreement to the contrary, all the partners are entitled to participate in the management. The management of the partnership is run by all the partners jointly. However, if there is an agreement that KD Kamath or one person will act on behalf of all, then it can be there. Otherwise, if there is no such agreement, then all the members of the partnership firm will participate into the decision making. They all will have equal voting power, equal decision making power. Okay, and they will all have equal saying in the running of the partnership, business of the partnership. And in the case of company, let's read how a company manages itself. Members of company are not entitled to take part in the management. Members are not entitled, okay, unless they are appointed as directors, in which case they may participate. Only directors are allowed to manage a company. Members of the company or the shareholders of the company can definitely cast their vote on the key aspects, but not on the day-to-day management of the company. Directors are responsible for that. Director may or may not be a member of the company. Okay. Members, however, enjoy the right to attending general meeting and voting where they can decide certain questions such as election of director, appointment of auditors, etc. But day-to-day running of the decision making regarding the business of the company is being taken by the directors. Okay. Directors only. Members do not have much say in it. Okay. Registration is not compulsory in the case of partnership. Partnership can come into existence even without registration. Like we discussed, it can come out of understanding as well, conduct as well, by implied agreement as well, by oral agreement as well. So when we allow these mode of existence for the partnership, that means registration is not mandatory, because registration can only be done of a written document. If we say registration is mandatory, that means we are saying that there cannot be a partnership which is based on oral understanding, which is based on mutual understanding, which is based on conduct, which is based on implied understanding. If we are making registration mandatory, then we are trying to say that this partnership firm can only come into existence only upon a written agreement, because only written things can be registered. Oral things cannot be registered. Okay, so because we can say partnership can come into existence without writing as well, therefore it means that registration is not compulsory in the case of partnership. You may not at all take a registration. It is not mandatory. It is flexible in this case. You may take it or you may not take it. If you want to take registration, you'll have to get yourself a registered deed. A company cannot come into existence unless it is registered under the Companies Act 2013 or earlier Act 1956. Okay, so company cannot come into existence without there being a registration first. Okay, because it's a separate legal entity. For getting separate legal entity, registration is mandatory. Otherwise, how would you become a separate legal entity without registration? Winding up. A partnership firm can be dissolved at any time if all the partners agree. Okay, if all the partners agree, you can decide to wind up the partnership firm anytime. You do not need anyone's permission. Whose permission is required to wind up a partnership? Permission of all the members of the partnership or even the majority of the partners. If they say that partnership has to be wound up, it will be wound up. Or if the managing partner feels that it's the right time to wind up the partnership, then you'll wind up the partnership. But in the case of a company is a legal person. Only law can create it and only law can kill it. Neither we can create it nor we can kill it. Okay, so it's a legal act, only law can do so. The company being a legal person is either wind up by the National Company Law Tribunal or its name is struck off by the Registrar of Companies. Okay, only a legal act can put an end to a company's life. Here we do not need a legal act, only the unanimous or a majoritarian act by the partners will put an end to the partnership. Number of members. Okay, the number of members shall not exceed 100. Okay, however, the rule given under the companies restrict the present limit to 50. Companies Act Section 464 says you can have up to 100 members, but now the rules frame under that particular act, it says only 50 is the number of partners you can have in a partnership. You cannot have more than 50 partners. Here, a private company may have 200 members. There may be a one person company, and there may be a public company which can have as many shareholders as possible. Only minimum restriction is given in the case of public company, that 7 initial members has to be there, but there can be as many members as possible in a public company. And another case of differentiation here may be that partnership cannot come into existence alone. Sole member cannot create a partnership, but here now we have a one person company concept as well, which says only one member can also set up a company. This also can be a another basis of differentiation. Duration of existence. Unless there is a contract to the contrary, death, retirement, or insolvency of a partner result in the dissolution of the firm. If there is a contract that in case of death or retirement of a firm or of a partner, we'll carry on business this and that way, okay, then it will happen. But suppose a partnership is based upon oral understanding or the conduct or the implied or mental understanding, then in the case, because partnership is between people, and if someone dies or someone retires automatically or someone is insolvent, when person is insolvent, he is not able to enter into a contract or to continue being into a contract earlierly entered by him. So in these cases, the firm will automatically come to an end, but the company enjoys a perpetual succession. Like we discussed, members may come and go, but company goes on forever. Members, all of the members may die, all of the shareholders may die, okay, at the same point of time, but still the company will keep continuing on because their successors, their children, okay, will take on the role of the earlier members. And the another differentiation which you can now have, you can now add it to it, another basis. But here, one person alone could also set up a company. There could be a one person company as well. Okay, here at least two people have to be there because we cannot have an agreement with ourselves. But here, one person company could also be there because we are having a contract with the company. Company is the other person here. Okay, so one person can have a company which is one person company, which is a new inclusion by the Companies Act. But Partnership Act, still you need at least two people in any case. Okay. So this is we are done with today's lecture. you can give it a glance to what we have studied today. Okay, just read it once and then we'll close it.